Welcome to Bufete Law Firm channel. In today's video, we'll explore an important aspect of Mexican law, civil liability in Mexico. We'll break down what civil liability means, how it's classified, and the key differences between objective and subjective liability. We'll also take a look at some important criteria established by the Supreme Court of Mexico. Whether you're studying law or just curious about how legal responsibility works in Mexico, this video will give you a clear overview. Let's dive in. 1. What is civil liability? Civil liability in Mexico refers to the obligation of an individual who causes harm to another to repair that harm. This damage can result from either the breach of a contract or the violation of the general duty that applies to all individuals to avoid harming others. According to the Supreme Court of Mexico, civil liability can be divided into two categories: contractual and non-contractual. In contractual liability, the parties are bound by a pre-existing agreement that has been breached, while in non-contractual or tort liability, the obligation arises from the occurrence of harmful acts. Therefore, contractual liability stems from the violation of a mutual agreement, whereas non-contractual liability is based on the general obligation not to cause harm to others. Second, objective versus subjective liability. Non-contractual liability in Mexico can be either objective or subjective. Subjective liability is based on the presence of fault or negligence. In this case, the individual must have either intended to cause harm or acted recklessly. Conversely, objective liability does not depend on intent or negligence. Instead, it is based on the harm caused by the use of dangerous objects or activities, even if there is no illicit intent. The Supreme Court has emphasized that under civil liability theory, the party causing harm must compensate the affected party. In the case of contractual liability, a breach of a pre-existing obligation is sufficient to establish liability. For non-contractual liability, the obligation can either be subjective, involving fault or negligence, or objective, where the harm is caused by inherently dangerous activities or objects. In this latter case, the individual may be held liable simply by engaging in activities that create a risk, regardless of whether the action was wrongful or negligent. The court further clarifies that subjective liability arises when the harm is caused by culpable conduct, such as fault or negligence, while objective liability applies when the harm results from the use of a dangerous object or activity. The lack of a subjective element, such as intent or fault, in objective liability is grounded in fairness. Those who create risks for others by engaging in potentially harmful activities must bear responsibility for any resulting harm, as they are deriving benefit from that activity. In summary, civil liability in Mexico can arise from both contractual and non-contractual obligations. The distinction between subjective and objective liability is crucial, as subjective liability focuses on fault or negligence, whereas objective liability applies in cases where the risk itself justifies holding the responsible party accountable, regardless of intent. Thank you for watching. At Bufete Law Firm, we're here to help you with all your legal needs with respect to an important aspect of Mexican law, civil liability. We broke down what civil liability means, how it's classified, and the key differences between objective and subjective liability. If you have any further questions or need legal assistance, don't hesitate to reach out. We're here to help. If you need advice on this matter, at Bufete Law Firm, attorneys at law, we can help you. Contact us at the phone numbers 55 28 79 81 69 and 55 51 83 9302, or via email at bufetelin@bufetelin.com.